elective course Ethics and Medical Jurisprudence, second BHMS professional course CBDC. This is module 4 about Indian medical jurisprudence. Lecture 2, topic is legal responsibility of homeopathic practitioner. Myself Dr. Ragini Raut, MD Home, HOD, Associate Professor, Department of Forensic Medicine and Toxicology, Bharati Vidyapeeth Homeopathic Medical College, Pune. Lecture 2 conducts about the legal responsibility of homeopathic practitioners. What is role and duties and responsibility in respect of homeopathic practitioner? The first is medical negligence and malpractices. Second is legal duties towards the patients, case laws and landmark judgments, regulatory bodies and their functions. Medical negligence and malpractice. Homeopathic practitioners in India are liable and there is medical negligence or malpractice. It is deficiency and failure to execute reasonable care and skill or willful negligence act of a medical practitioner which causes some harm or bodily injury or death of the patient. Negligence may be act of omission or act of commission where reasonable man under the circumstances would not do or do. So, these are the do's and don'ts in relation with the physician. As per the Bachelor Dictionary, there are 4 essential ingredients to cause negligence. One is duty, second is dereliction, third is direct cause and fourth is damage. Medical practitioner has a duty to treat a patient with reasonable skill and care. If he is not executing that duty, it will be amount to negligence. Medical negligence and malpractice. The doctrine of RES, that is ipsa liciter, means thing speaks for itself and the patient need not prove negligence when this doctrine is applied. The burden of providing the innocence lies upon the doctor. Some of the examples are burns from application of hot water, breaking of the needles when injections are given, blood transfusion mismatch hazards, too tight plaster cast causing gangrene. Negligence are of 2 types as per law, civil negligence and criminal negligence. Defense against medical negligence, that is calculated risk doctrine, then contributor negligence, vicarious liability and corporate negligence. Fifth is products liability, sixth is medical maloccurrence, seventh is therapeutic misadventure, eighth is error in the judgment, ninth is res indica, 10th is res judicata, 11th is composite negligence. Precautions to avoid negligence stare. First is doctor should get informed consent from the patient. This is very important aspect. He should establish a rapport with the patients, that is doctor patient relationship. He should keep full and accurate medical records, that is record keeping is again important phenomena. Then employ ordinary skill and care throughout the treatment. Do necessary blood tests, X-ray and indicated investigations to arrive a diagnosis. Wherever it is indicated and required, one should ask for the investigation. Immunization should be done whenever necessary, particularly for the tetanus. Sensitivity tests should be done before full dose of injection, that is a trial dose should be done before giving the full dose. Get the opinion from the other doctor if it is necessary. In suspected cases of malignity or necessary tests should be done before injections. The conditions of the patient should be informed to the relatives in the critical situations. Do not give too much promise to the patient. Do not guarantee a cure or do not claim for the 100% cure. Each steps of the treatment must be conveyed to the patient or to his relatives. If the facilities are inadequate, refer the patient to other institute where the facilities are available. In the 15th point, the multi-stage treatment specific and separate consent should be taken at each stage and the patient should be informed about it. When a new drug is administered, strictly follow the guidelines laid down by Indian Medical Council research, that is ICMR. Keep the operation theatres sterilized and infection free. In case of differential diagnosis, the reasons, symptoms and the clinical findings supporting the same must be meticulously recorded. Effort must be arrived at a final diagnosis if possible, and the same must be recorded. Every medical act must be accordance with the prevailing practice acceptable to the doctors of that specialty. Record meticulously the changing clinical profile of the patient and the steps taken to diagnose and manage the same. Medical indemnity insurance. It is a contract between the insurance company and the doctor to compensate in professional negligence in return for the payments of the premium. The objectives of medical indemnity insurance is to protect the professional interest of the doctor, to pay the conduct of defense of doctor in medical negligence, to compensate the amount the court declares to the opposite party. Homeopaths are liable under the laws Indian Penal Code, that is IPC 1860 section 304A, causing death by negligence, section 106/1 BNS 2023 and 338, causing grievous hurt by act of endangering the life, section 125 BNS 2023. Consumer Protection Act 1986. Homeopathic practitioners can be held liable for deficiency in the service. The medical practitioner against whom a complaint is made or the complaint fails or omits to comply with any other made by the district forum, the state commission or the national commission, as the case may be, such medical practitioner or complainant shall be punishable with imprisonment for a term which shall not be less than 1 month, but which may be extended to 3 years, or with fine which shall not be less than 2000 rupees, but which may extend to 10,000 rupees, or with the both. Medical Council Act 1956. Homeopathic practitioners registered under this act can face disciplinary action for professional misconduct. National Commission of Homeopathy Act 2020 regulates homeopathic education and practice and provides for disciplinary action against practitioners. 3 principles of homeopathic practice: the law of similars like, cures like. One of the 3 principles of homeopathy in the law, similars, similia similibus curantur, which means like cures like. The individualization of the case, the minimum dose. Indian Medical Central Council Act 1970 regulates Indian medicine including homeopathy and provides for disciplinary action. Clinical Establishment Registration and Regulation Act 2010 regulates clinical establishments including homeopathic clinics. A liability can rise from failure to diagnose or treat a condition, administration of wrong medication or dosage, failure to obtain informed consent, breach of standard of care, negligence in treatment or management. Homeopathic practitioners can face criminal liability, fine, imprisonment or both, civil liability, compensation to the patients, disciplinary action, suspension or removal from the register, and loss of reputation and credibility in the society. It is essential for homeopathic practitioners to maintain proper records, follow standard treatments protocol, and obtain informed consent to minimize the risk of legal liabilities. The homeopathic practitioners in India have legal responsibilities and duties towards the patients, including duty of care, where they have to provide reasonable care and skill while treating the patients. Then informed consent, obtain patient consent before treatment, disclosing the risk and benefits, confidentiality, maintain patient's confidentiality and privacy, documentation, keep accurate and detailed records of patient's treatment. Fifth is standard of care, follow established homeopathic standards and protocols. Sixth is patient safety, which ensure a safe environment for the patients. Seventh is emergency care, provide emergency care and refer patients to other healthcare professionals when necessary. Eighth is disclosure of risks, inform patients to potential risks and side effects of the treatment. Patients' autonomy, respect patients' right to make informed decisions about their treatment. 10th is continuity of care, ensure continuity of care and referral to other healthcare professionals when necessary. 11th is medical negligence, avoid medical negligence and take reasonable care to prevent harm to the patients. 12th is patient communication, communicate effectively with patients and their families. Legal duties also include complying with relevant laws and regulations, maintaining professional registration and licensure, participating in continuing education and professional development, respecting patients' rights and dignity, avoiding conflicts of interest. Legal duties toward the patients. By fulfilling these legal responsibilities and duties, homeopathic practitioner can ensure they are providing quality care to the patients while minimize the risk of legal liability. Then second component is case laws and landmark judgments. Laws applicable to homeopathic practitioner: National Commission of Homeopathy Act 2020, Consumer Protection Act 1986, Medical Negligence Law, that is Indian Penal Code 1860 under section 304A, section 106 subsection 1, BNS 2023, the Drugs and Cosmetic Act 1940. Case laws, and there are certain landmark judgments. Landmark judgments: Poonam Verma versus Ashwin Patel in 1996. Supreme Court held homeopathic practitioners liable for medical negligence. Supreme Court held respondent 1, a homeopath, liable for negligence per se despite lacking qualifications in the allopathy. He prescribed allopathic drugs leading to the patient's deterioration in 24 Jan 2024. Dr. R.K. Chaudhary versus State of Rajasthan 2013, Rajasthan High Court emphasized the importance of informed consent. Third is Dr. Suresh Gupta versus Government of NCT of Delhi 2004. Supreme Court established